Hello, my name is David Smith and I'm Training Manager at Bidwell Henderson Cost Consultants, currently sat in the ever gloriously sunny Newcastle upon Tyne. Hopefully you can't hear the sound of the rain bouncing down outside. We just wanted to do a quick video to highlight the changes that the Legal Aid Agency have made to their expert witness guidance. This guidance is found in the document that's snappily titled The Guidance on the Remuneration of Expert Witnesses in Family Cases. Now, this might not sound like it's the most exciting of updates, but there are some welcome changes here that are definitely worthwhile taking a moment to consider. The first major change is in relation to experts claiming at a higher hourly rate than the codified rates, those maximum rates that are set out in the remuneration regulations. So previously, the Legal Aid Agency would only pay a higher rate if prior authority was obtained. However, the updated guidance provides for two circumstances when a higher rate would be payable. Firstly, if on assessment you can justify why prior authority was not applied for and why the fees needed to exceed those maximum rates. The example given is if there's an urgent instruction that had been required. So the Legal Aid Agency will assess this on a case-by-case basis based on the justification that you provide. And the second situation is when the hourly rate exceeds the codified rate, the remuneration regulations, but falls within the new guideline rates at Annex 5 of the guidance. Still with me? So this part of Annex 5, essentially we have a list of experts where there's been an identified shortage of availability, which has resulted in the LAA routinely allowing a higher rate on prior authority applications for those experts. Now they include a geneticist, lip reader or signer or deaf intermediary, paediatric neuroradiologists and London-based paediatricians. So Annex 5 has some new rates for these experts that are higher than the codified rates, but are ones that will be paid on assessment without prior authority being required. Additionally, Annex 5 also provides a list of guideline rates for some types of experts who are not included in the remuneration regulations. Now this includes endocrinologist, genetic testing, nephrologist, ophthalmologist, including paediatric ophthalmologist, finally paediatric hematologist. So we now have guideline rates for those experts. Bear these in mind if you're going to be instructing one of those experts on a case. This LAA guidance document should be your first port of call whenever you're establishing what rates are allowable for certain types of experts. There's also a number of other amendments to the guidance which provide additional clarification in certain areas. So firstly, the Legal Aid Agency has clarified that for the purposes of their recommended number of hours that they have for psychologists and psychiatrists preparing reports, they would consider an additional 10 hours for each additional party being assessed to be appropriate. There's also confirmation in there that in CCMS, users can only request prior authority for themselves. However, on a joint instruction, the provider making the application can provide the certificate references of the other parties as part of the application, and if successful, all those other parties are covered by the prior authority and will be sent a notification in CCMS. We recommend that if you have that, you keep a copy of that notification somewhere on file when it comes to the billing stage. The guidance on risk assessments has been broadened to include references to cases involving domestic abuse or physical harm, potentially qualifying for that higher risk assessment rate. We also have additional guidance regarding translation of documents, common area of reduction assessment this. The new part of the guidance states, if the court has listed the specific documents or parts of documents that need to be translated, then this is sufficient evidence for it to be funded at legal aid rates and prior authority will not be required. Okay, the next change, we have some further clarification on the use of intermediaries. Now the position remains that the legal aid will not pay for, I quote, fees charged for witness intermediary services provided in court, reports in advance of such work, and other work in preparation for ancillary to court proceedings. However, they've added clarification to say that funding can be provided for an intermediary or lay advocate to be used for communication between a provider and their client away from the courtroom in the course of legal representation provided, subject to the LAA being satisfied that it's justifiable and reasonable disbursement. Final change regards process servers, and where they've attempted service on more than 3 occasions, this should be justified by the provider or the process server. Without that justification, you run the risk of that being reduced on assessment. Now, as always, an important part of ensuring you're maximising your costs is making sure you don't encounter shortfalls on assessment. So being aware of all this latest guidance regarding experts is an integral part of that. Further details of the guidance are available on our website, together with a link to the guidance document itself for you to have a look at. Okay, that's the end of this very quick update. I hope you found it to be useful, and I apologise for the lack of a suitable bookcase behind you, which seems to be the way that you have to do these things at the moment, but thank you for listening.